Courtroom going live, now we're bringing you the heat. From the judge to the jury, everybody's on screen. We're from the Live Zoom court, you know what I mean. Boots on the floor, but the courtroom's online. Judge on the screen and the case is in line. From Texas to the world, we're watching it unfold. Every single hearing got a story to be told. Click that link, microphone on mute. Everybody watching, trying to figure out the truth. Gavel hits hard, chat starts going crazy. Courtroom gets quiet when the judge says maybe. Live Zoom court, everybody tune in from the courthouse screen. Let the proceedings begin. Judge on camera, gavel coming down. Case is going live from every side of town. Live Zoom court, from the country to the city. Real courtroom moments and the chat gets gritty. Turn that volume up, let the whole world see. Live Zoom court, streaming justice digitally. Red light flashing, yeah, we're live on the scene. No courthouse hallway, just a computer screen. Attorney speaking, defendant standing by. Judge looks serious, everybody asking why. Country road, city streets, different courtroom doors. But when that gavel hits, everybody wants more. No Hollywood script, no movie set scene. Just real proceedings happen, live on the screen. Mic check, 1, 2, everybody locked in. Court starts now, let the hearing begin. Judge got the facts, attorney's got the case. Everybody watching every move and every face. From the Lone Star State to courts worldwide. Different location, but the same legal right. Chat moving fast, notifications ring. When the judge says order, everybody does their thing. Live Zoom court, everybody tune in from the courthouse screen. Let the proceedings begin. Judge on camera, gavel coming down. Case is going live from every side of town. Live Zoom court, from the country to the city. Real courtroom moments and the chat gets gritty. Turn that volume up, let the whole world see. Live Zoom court, streaming justice digitally. So grab your seat, keep your eyes on the screen. You never know what the next hearing might mean. From country roads to the courtroom floor, we'll see you next time on Live Zoom Court.
Welcome back to Live Zoom Court. We are back with Judge Porter. Got 2 more cases with him.
All right. Rodrigo Hernandez. Are you Mr. Hernandez?
Yes, sir.
Mr. Hernandez, the law says when you're brought into detention and initially detained, you must see a judge every 10 business days. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And Ms. Herrick, your attorney, is here. Do you see her on the screen?
Yes, sir.
All right. Ms. Gonzalez, what brings Mr. Hernandez to court today?
Good morning, Your Honor. Rodrigo was referred into our detention center for the offense of ag assault with a deadly weapon ×3. That occurred August the 25th, 2020. According to the Fort Worth Police report, it took place at approximately 7:55 p.m. They were dispatched to the disturbance at the address 3611 Noble Avenue. According to the police report, victim, Ms. Roth, called the police after she saw suspect pull out a gun and shoot at their vehicle, which was a red Dodge Ram. While she and 2 others were located inside the vehicle,
Let me
Mr.
fix
Roth
this
and
here.
Mr. Lopez. According to Mr. Roth, they were in the vehicle going east when he heard 5 gunshots and saw suspects aiming a handgun at them. The suspect aiming a handgun at them. According to Mr. Lopez, he was working on his red Dodge Ram earlier that day when the suspect approached him to ask why he was looking at his girlfriend. According to the police report, the suspect demanded an apology from Mr. Lopez. Lopez said that he walked away from the suspect and went inside the house. 10 minutes later, or approximately, Mr. Lopez, his sister, and his brother-in-law came out, drove to McDonald's. When they returned, he noticed a large group of people standing outside the home. So he attempted to turn around in reverse to drive eastbound on Noble As he drove by, he was shot at. There were multiple bullet
Damn.
holes in the red Dodge Ram. 9 bullet shell casings on the ground were located in the street. Victim 1, 2, and 3 were all in fear of serious bodily injury from suspect after witnessing suspect point the firearm towards them. The suspect's mother, Miss Maria Alvarez, who's also present via Zoom today, called the police to give them the location of her son, Mr. Rodrigo. He was located and arrested for aggravated assault with a deadly weapon and been transported to the juvenile detention center.
Shit.
Do you have prior referrals to the department?
He does, Your Honor. He was previously referred in to our department for assault public servant back in October of 2016. He was put on
Heavy,
probation
chat.
for that.
Heavy.
That
Heavy.
offense, May 16 of 2017, he completed that probation term. Then he was re-referred into our detention center for evading arrest detention back in November of 2019, which he is currently on probation for, Your Honor. There was another case that he was referred on for criminal trespass back in November of 2019.
Criminal trespass.
And that is my understanding was waived non-suit DA.
Yeah, I thought his evading probation expired in September.
He well, technically, because he's got a pending case right now, it's still open, is my understanding.
Was a motion to modify filed in the prior case?
Yes, that's correct, Your Honor. We were set for a motion to modify an adjudication disposition hearing this morning. However, it was passed.
No, we were only set on the new case this morning.
Yeah, an adjudication disposition.
If I
correct.
may, I thought the violation of probation had been rejected. Is that right, Andy?
I do not.
Sorry, no,
Ms.
Andy.
Smith.
Yes.
Sorry,
I
Ms.
would never
Smith.
call you Andy ever.
Andy Porter,
yes,
wow.
Actually, now that I'm looking at my on my end,
Damn,
it was,
Lisa.
Supervisory caution. And
Okay.
I did that, if I remember
Okay.
correctly.
And I don't have any notes on my doc. I've got the file right in front of me. I don't have any notes on why today's case was passed.
It is because Andy Smith is taking the case to the grand jury. Is that right?
Yeah, and I didn't realize that you were appointed. It was originally Randy Bowers. Sorry, Judge, I talked to Mary about this yesterday. It was originally Randy, didn't realize she got off and that Lisa was appointed. So I just opened up to evidence for her yesterday.
Okay.
And then I do also intend on taking this to grand jury.
All right.
Grand jury,
Well.
damn.
Mr. Hernandez, that puts us on a completely separate track. This is a gun offense, and it
A PPU.
offense times 3. Is this let's see, let me not guess, since I have the petition right in front of me.
Andy Porter.
Okay. So this is aggravated assault by threat, aggravated assault by threat, aggravated assault by threat, deadly weapon times 3. Yeah, that scares me too much. That scares me too much. I can't. You've been previously found to have engaged in delinquent conduct. So yes, you're on level 1-0. You need to stay on level 1-0 because that puts your attorney in the best possible bargaining position on your behalf. Plus, Judge, this is probably going to be Judge Kim's case now. And if you're anything other than level 1, you're just killing yourself in his eyes.
Yeah.
You want to maintain level 1-0 because that makes Judge Kim very happy. And that gives your attorney, who knows how Judge Kim operates, puts her in the best possible position to argue on your behalf. But the underlying facts are just too scary. I can't authorize your release today. I'm sorry.
Yes, sir.
All right, that's going to be the order of the court. Thank you, Ms. Harry.
Oh. Got 2 more cases.
I didn't even ask if you had a parent or guardian here today.
She is, I think, and she also is not well. She's undergoing chemotherapy, I believe.
Mm-hmm.
So I believe she's here.
All right, thank you. Okay. All right, are you Miss Page?
Miss Page.
I can't hear you. All right, Miss Page. The law says when you're brought into detention, you must see a judge within 2 business days, and this is your initial detention hearing. Is somebody covering for Mr. Victorson?
Yes, sir.
Oh,
Frank
thank you,
Minicon.
Mr. Minicon.
Sir.
She was brought in on a TJJD warrant.
Judge, my understanding is that she was brought in for a UUMV is what I'm looking at, the offense report or the detention hearing report.
Oh, but okay. She's previously been to TJJD, but she's been discharged from parole.
That's correct.
Discharged
Ms.
from
Page, before I go any
parole.
further, you have the right to remain silent. You also have the right to an attorney, and your attorney, Ms. Herrick, is I've appointed. You see her on the screen?
Hi, Kaylin.
All right.
Lisa
Herrick, what are your
Herrick.
thoughts?
I understand that this is a challenging position because she has previously been to TJJD. Her offense that she's accused of right now is not a violent offense. She is young. She's 15 years old.
15 years old,
Yeah.
damn.
And so, I mean, my request is that she be released, even if that is on an electronic monitor, because, like you said, she is not still obligated to TJJD in any way right now.
Does she have a parent or guardian here?
Unfortunately, Judge, her grandmother is not present. I looked at the notes and she said she was going to try to be here or try to be present on the Zoom, but she is not available on the Zoom, nor do I see her in the building.
Before I go any further and I forget, it's the police report indicates that yesterday at a little after midnight, 4 police officers observed a car that you and your sister were driving. Police ran the plates and it was reported stolen 2 days earlier. They initiated a traffic
Stolen
stop
car.
and apprehended both. So we don't need to go any further than that. First, I found there's probable cause to believe that you've engaged in delinquent conduct. And second of all, because I don't have a parent or guardian to release you to today, I have to order that you be detained. All right? All right.
And she is
Thank you.
detained.
Thank you, Judge.
Thank you, Judge.
I'll be right back, y'all.
All right, Dakota Reynolds. Is Mr. Adeniji here?
I've seen him on the Zoom feed, Your Honor.
Yeah. Let's see if I can get him.
I see him and he's muted.
Correct. I sent him a message asking. Here he comes. All right.
Right here, Judge. Judge, did I hear you say you're hard of hearing?
Sometimes, yes.
Okay, because I don't see any earpiece.
All right. All right. Are you Mr. Reynolds?
Yes, sir.
Mr. Reynolds, can you speak up a little louder for me?
Yes, sir.
Ah, there we go. All right, Mr. Reynolds, the law says when you're brought into detention, you must see a judge within 2 business days. This is your initial detention hearing. Actually, it's a hearing requested by your attorney. So you have the right to remain silent. You also have the right to an attorney. Mr. Adeniji, your attorney is here to represent you. Mr. Lewis, if you could remind me what brings Mr. Reynolds to court today.
Yes, sir, and I'm going to try to be as concise as possible because it's something of a long
We do have a
story.
live chase going on right now, y'all.
Dakota is pending a determinative sentence hearing scheduled
We
for
will be
October
streaming it.
23rd for 2 counts of aggravated robbery. The incident occurred in April. The allegations are that on April 13th, the 2 victims were lured to a residence to purchase an iPhone by way of a app.
After
And
this
upon
case, we
arrival,
go over to the
suspect
chase.
allegedly brandished a handgun at them. One of the victims threw the $200 she had brought to purchase the iPhone down, and also her backpack as they ran. And Dakota was identified as the suspect via the app's law enforcement liaison and also through a photo lineup shown of both victims. Dakota has been out on electronic monitor pretty much since his original arrest. There have been some difficulties on the monitor. Most recently in September, grandmother with whom he was staying at the time and with whom he normally lives complained of a litany of complaints of friends coming over to her property without her permission. Marijuana use on her property, violations of the
Marijuana.
There was an incident on the 14th where a car that Dakota had somehow purchased was illegally parked. A wrecker and the police had to be called, and an incident occurred which resulted in him being arrested for a Class C misdemeanor. We had an out of custody detention hearing to address this with Judge Kim on, I believe it was the 17th. Judge Kim Dakota detained. We had a 10-day on, I believe it was the 1st, in front of Judge Terry. And at the time, Dakota was level 1 outstanding. Judge Terry, at that hearing, did his release to his aunt on an electronic monitor if he were to retain his level 1 outstanding status through the upcoming weekend. And I was to check back with her this past Monday. I did. He was level 1 outstanding this Monday, but he had been dropped to level 1 acceptable, according to JCMS. Judge Terry declined to release him based on the level drop over the weekend, but subsequent to that, detention informed me that Dakota had successfully appealed his points loss and his level drop, and they restored the record to show that he was in fact level 1 outstanding through the weekend. I went back to Judge Terry and she advised that this could be placed on the detention docket for today, although she wasn't quite ready to release him at that point. That was a couple days ago. Since that time, he has dropped to level 2 outstanding.
Level 2 outstanding.
And, but Mom and Grandma are here?
Grandmother is not, Your Honor.
Grandmother, what are your thoughts?
My thoughts, Dakota, I don't know why he dropped to the level that he did over there while he was there. But I came because he wanted to see if he can go live with my daughter to keep down the confusion with the guys coming back and forward to the house and, on my property, because I got to deal with a lot of things right now concerning my wife and everything, her illness and stuff. So we was just trying to get him into another, with my daughter, who could watch him more than I can right now, because going back and forward to dialysis with her and doing the things that I do.
And forgive me, a couple of months ago, wasn't somebody in your house, wasn't there a fear that somebody was exposed to COVID?
My wife. Mm-hmm.
I thought about this because Dakota and I had that conversation like at the beginning of the summer when I let him go, and I warned him that all of his running around business is going to get one of y'all sick. Didn't he and I have that conversation?
Yeah. Yes, sir.
And then what happened?
And then you got someone sick.
I don't know how she how she caught the, we still kind of how she got it. But
Exactly.
Yeah.
See, Dakota, I remember these things. That isn't good for you. I warned you that you could do something that might kill one of your moms. And that is not what you want to happen. And now here we are. You're back in detention. All right, Mr. Adeniji, give it your best shot.
Judge, what the court is referencing has been overtaken by events since then. The last time we're in court, which was last week actually, Judge Terry actually said, I will release you if you maintain level 1O. And he did. But because of paperwork mixed up in the back, is the reason why we are back here. He should have been released. He's not responsible for the paperwork or the gradings. They corrected the error they made. So it's unfortunate that he's still here, contrary to Judge Terry's disposition. So I will, and I regret that
he
if
should
he
stay in
wasn't here,
detention.
we won't be talking about level 2O.
He should stay in detention.
I don't know how to be fair to him in terms of meeting his obligation to be level 1 who are standing, and I will release you. And then some people mess up the paperwork and he's still here. Now he's frustrated. I don't know what happened, why he got to level 2 outstanding, but I know your policy. So that's what I'm concerned about.
All right. I'm going to look up what happened in the back.
Okay. I appreciate that, Judge.
Oh, well, he fell from 1-0 to 2 unacceptable.
Oh, I thought you said 2.
Because he wasn't doing his schoolwork.
Okay.
And not following instructions.
Oh.
Oh, Dakota.
Dakota.
Man.
What are you doing?
Because I was sleeping.
I can't hear you.
Because I was sleeping. Because I was mad. Because I was already been there. Then I was just supposed to go home. Then Johnny spoke to me. And then he was like, they messed up my points and stuff.
Dakota. Gotta be level 1 outstanding.
Nope. Not going to do it. Not going to do it. You need to get to level 1-0.
Judge, how many days?
That's what I'm looking at.
Okay.
Get to 1-0, maintain it for 7 days, and then I will authorize release to your aunt, but not today.
So we're talking about next week, Thursday.
Yes, sir.
Okay.
Sorry.
I think that's fair.
He burned me personally, you know?
And that's why it shouldn't be in your court today.
Mr. Indonesia and I are laughing, and we're laughing at Judge Porter because Judge Porter actually just remembered this.
That's a disadvantage right there, Judge.
Okay. Yeah. No.
Dakota.
Sorry, Dakota.
So, Judge, we have it on record that if it maintains level 1.
We are switching to the chase right now while we get another.
As again, people were out in that parking lot, had no idea, and now this narrow streets, people maybe in and out of their homes, and they don't want to deal with this guy who could be a big threat to the community. Very dangerous. There's a pedestrian right there.
Maybe walking their dog, kids
right?
Maybe riding their bikes. I know a lot of kids are back in school, but it just depends.
Yeah, a lot of kids back in school. Them being in the school probably going to be a huge plus. But anybody that may be on the roadway right now, especially with that impaired driver behind the wheel, and even though it is a relatively slow speed pursuit, can't get a peek where the law enforcement is. They're still right behind him. And this might be one of those ones where this guy just drives around until he feels like, you know, he's just going to decide to pull over. And that might be a good thing, but also it might still be very dangerous. This person clearly inebriated and you know, driving a vehicle. Maybe he's going to miss something. Maybe there's going to be a problem. That's one of the reasons why we always watch these, and we're always concerned about the public, the safety of the public. Law enforcement, they're worried about the public, they're worried about their officers, and they're also worried about that suspect behind the wheel.
Oh, I thought there could have been a chance to make a move there as the suspect was stuck in traffic, but clearly the person is now maneuvering through the Van Nuys area, maybe onto a little bit more of a better area that is not as residential. I can't see unless you pull out a little bit. Yes, so more business friendly.
Wrong side of the road. First time, wrong side of the road.
Right.
Wrong side of the road.
Driving the wrong side of the road here,
Yeah,
blowing through stop signs and stoplights now, and picking up speed here. This is on, what, is this Van Nuys or Van Nuys?
We're back on Van Owen. We just crossed over Sepulveda, and we're making our way back over towards the freeway. I just heard him talking about, you know, one of the officers asking if they could do the pit maneuver, and basically they're saying just because of the other traffic in the area and speeds, they're going to prevent. They're saying no pit right now, no pit at all. If that,
no
you know,
pit.
If everything changes, they might be able to do that, but right now it's still a hard no. Could they put the spike strips out? That's still a possibility, even though we are like on these very residential, you know, some of them residential, some of them majors. But look at the traffic, and now that he's on Haskell, we know this is pretty much a straight shot over to Sherman Way. The officers that are in this area probably know this. Know these streets like the back of their hands, and they would have that opportunity maybe to get ahead of the chase and to be able to put out those spike strips. Speeds definitely increasing. Traffic is probably going to be a problem when he gets over to Sherman Way.
Well, you know, the other reason that a pit maneuver is not authorized, thank you to Gigi for keeping us informed here. Some officers are saying that they believe there are 2 to 3 suspects in this vehicle.
2 to 3 suspects?
And that is a reason why the pit maneuver was not authorized. There's more than one occupant in the car, so I believe that is a deterrent as to why they may try to avoid that. I know we can't see because those windows are quite tinted, but it is believed that there's more than just that driver in that vehicle.
In the Van
Nuys. You
Nuys.
get Sky Fox to go around to the front. That doesn't mean they're not in the back seat, but maybe we can see if there is a passenger in that vehicle, and if there's more people in the car, maybe that's the reason why they're. That clearly is the reason. Excuse me. That clearly is the reason why they're not doing that pit maneuver right now. Looks like we're setting up for maybe a right turn or something else right
he's
there.
looking out the
Here
window.
we go.
He's looking behind him.
We have windows open.
Oh, here we go. Now we're going to
illegal U-turn.
That front seat definitely appears to
empty.
be empty.
Yeah.
And the
Appears
back
to be
seat,
empty.
There was a shot there where the lighting, I could actually see the seat. I'm not going to say 100%, but I'm guessing that there is nobody in that back seat. So it's probably just the driver. But if officers have that possibility, it's the same thing. They have the possibility, so they're not going to do it.
Right, taking all precautions to make sure everyone's safe and make the right decisions in terms of when they pursue somebody like this, a suspect. Again, the initial one was a burglary, not clear on a lot of the details there. What time did that come across? Because we've been following this now for a little bit of time, right, Stu? When did it first all start?
Probably right about the 1 o'clock hour. Maybe like just, if it was shortly after 1, it was just a few minutes after 1 o'clock. Skyfox is going to do a pretty pirouette right here. If anybody's at home, please make sure that if you're standing, don't get dizzy. Oh, Tyler doing an amazing job keeping that shot for us. Let's see if we can get a better look. Yeah, clearly nobody in that front seat.
Nobody in the front
but
seat.
The speed's definitely picking up once again. That was a quick, if you blinked, you
We
probably
got a
missed
live
the,
chase for
LAPD
y'all.
airship,
Yeah.
coming up to
A burglary suspect
but apparently that light
in the
was
Van
green.
Nuys.
And but a little bit more traffic, something we don't want to see. Law enforcement doesn't want to see that either. But the chase continues out here in the Van Nuys area. And that suspect basically staying in this neighborhood. I have a feeling, yeah, we're right by Woodley, so we're getting very close to the Van Nuys Airport once again as we work our way down Woodley
Van Nuys Airport coming up.
Sherman Way.
Well, the good thing is, from what we see right here, wide open lanes, so that is certainly relief when it comes to, the public being at jeopardy or in risk of danger. But now we're seeing a little bit more traffic as he picks up his speed a little. But we do not see the officers behind him at this point.
No
Obviously,
officers
they're still
behind
tracking
him.
Again, Woodley and Roscoe area by the Van Nuys Airport. But you were mentioning we picked this up about 10 o'clock, I believe, so...
The choices he's making, the streets are going to get a little bit more crowded. There's definitely going to be a lot more traffic than we've seen, especially on Woodley.
Well, yeah, and the more traffic, obviously more people involved, and the potential of something going wrong goes up, obviously, with so many innocent drivers or bystanders in the way. So it is concerning. And to be clear, we're not in tracking mode at this point, Stu. We do see those police cruisers behind this individual.
Uh-oh. Hold on, y'all. Switch over to a different feed. I don't know what's happening here.
Onto the 405. So this is going to change the.
We got
the
a
sort of course of
ABC
pursuit as well,
on them
because
now.
Now the CHP within the LAPD. So hopefully the CHP
Going on
is in this area. That we obviously know
405.
the CHP is
We're
aware,
going
but at what
80
point
miles an
do they
hour.
start getting involved?
There would be a mutual aid request from LAPD asking for their involvement, considering they're on the freeway now, asking them to take over because they're more well versed in driving on the freeway.
Going to small claims court. Since we are not doing anything here. Be keeping an eye on this here.
Cover 100% of the cost, and that she had the choice if we would pay for the removal of the old material.
Okay. And you sent that text when?
That text was sent
All the
are
people here
paying
on
for
small
the replacement
claims.
of the wooden fences between us, and I named all three of the fences: Neveling, Moe, and Ramirez. 2 of the wooden panels of the 3 between Neveling and our home blew down. We are clearing the path along the wooden section, continuing past the T-post, the bamboo mesh, the wire fence, and from the street to the pressure-treated post by the huge wall of the privet before our garden. The old wood panels and post will be removed by Cool Cat Fence Company. We can have them bundle your bamboo mesh, roll the wire, and leave the T-post for you. There was no reply to that email.
Okay, and was that sent with a receipt request? Did you
It was
see
a
that?
text message.
Right. So did it show that it was delivered?
Yes.
It couldn't be. Okay, so it said delivered underneath. your
There was
version of
no,
the text.
when I send a text, it'll tell me in red off to the side if it's, if it failed. It did not. I had no
Okay.
indication, and again, on 3/26, when they were installing the fence, it was the first I had heard that she did
Right.
not receive it. And then I read it to her and Bonnie while they were there. So that is their notice also.
Okay.
After the pet store.
All right. And so do you have the text on your phone?
I have it on mine, and Joyce had me do a screen print and mail it to her certified mail, I think. And she
Okay,
also
and
has
does
it, and it's in the evidences.
Does it say delivered underneath the text?
It doesn't say not delivered. I mean,
It just
it's
says
just like
failed.
my,
Yeah, it just
my-
says, it just says failed if it doesn't go through. It doesn't say delivered. I mean, on some phones it does say delivered. I don't know on hers if it does or not. I don't think hers
She
says
probably
failed.
has an Android.
I didn't say, it says failed.
Was it sent on an iPhone, Ms. Romo?
yes. I think I
An
have-
old iPhone,
Yeah.
yes.
Ms. Lieveling, is yours an iPhone?
Mine's an Android, but here's the text right here, and you can see it doesn't say delivered, it doesn't say failed, it doesn't say anything.
Right.
I never
Okay.
received it.
Right. Okay. So Ms. Lieveling claims that she did not receive the text, and
Did not receive the
and
text.
Ms. Romo says she wasn't aware that Ms. Lieveling was blocking their text since last summer. Should they have been aware of that? Was that something you?
Yes, I sent them a 4-page email ending the friendship and explaining, do not ever contact me again. And I've never seen them
Oh,
since last
damn.
summer. So they knew friendship was done, do not contact me.
Okay, and your immediate neighbors?
Pardon me?
Your immediate neighbors?
Yes.
Okay. And you sent that like last July or something?
Last July?
Summer of 2025, the last time we went hiking, I sent them.
Okay. So between then and March, do you see them? You lived right next door to each other,
No,
and you
but
don't see each other?
I had my privacy fence that they tore down, and then my whole front yard is 6-foot tall ivy.
Mhm.
And then I have a gate. And so their house is actually across the street, but over one, then they have a guest house right next to me. So the pictures that they sent in for evidence circling the fern, that's actually their guest house. That's directly next to me.
And that's where the fence was?
Yes, the fence was there.
Okay. And Ms. Romo, your thoughts as to not going over and knocking on Ms.
Neveling.
Ms. Lieveling, Joyce's door,
Miss Lingling.
and at some point saying, hey, we're thinking of taking down the fence. I know we're not supposed to be talking, but I thought I should clear this with you first. What was your thought on that?
Talking with Joyce, I thought it was very clear that she had moved on, and we were fine with that. However, the boundary line on January 14th, Thurston County sent a letter to the four of us, Joyce, us, Karen and Vicky, our neighbors next to Joyce, Eric, and Barbara Imperio, and to Maria Ramirez, our other neighbors. So all four neighbors received a letter from Thurston County explaining the boundary line survey that was attached that became the prevailing survey because of the settlement through the courts of where the boundary lines agreed to.
Okay, but let me go back to what we talked about earlier, which is you're not asserting authority over the fence because of a boundary line issue. You're agreeing right now for purposes of this case that the fence was on the property line or on Joyce's property, and you proceeded to remove the fences. Am I accurate in that?
I'm sorry, Judge. I was trying to respond to the fact that it was not unusual for her not to give us a reply, either to my text, or from Thurston County, or from a real estate attorney trying to explain the situation of the boundary line fence.
Okay. And by that, what was there a meeting with an attorney who offered to meet with Joyce, or what's the story there?
Yes.
Would you like my version?
Okay, I'll come. So was there a meeting set up or something? I couldn't tell what you meant.
There was a letter sent to explain how we can resolve this issue.
Amicably.
Yes. And we're trying to operate in good faith, trying to have clear communications, and not coming from us, but from Thurston County or from a real estate attorney to help us resolve. In the meantime, the fence we wanted to replace
as it was,
offer as it was without contesting.
She's not answering the
so
question.
We're just dealing with replacing the old fence and giving her the option of the material, either to keep it or to have us take it away. Not getting a reply, we went ahead and just left the material there, and then dealing with it on that day. Just trying to do the best we could to get the replacement fence in place. So we
weren't trying to encroach. We were just trying to replace a fence.
Yeah, the whole my property and trespassing, that's to be resolved by following the guidelines of what the assessor's office is saying, what we're paying property taxes on, and what the attorney.
But that's nothing to do with
But
today.
that's, yeah, the fence is replaced. We have a privacy fence there. And the materials, we offered to pay for the materials for the materials, but not to give her cash in her pocket for
us replacing a brand new fence.
For us replacing the fence, paying 100% cost.
Yeah.
Would you like to? Sorry.
So it looks like the letter from Ms. Wood went out in June, so subsequent to the taking down of the fence. Does that sound correct?
Shit.
Yes, Ms. Wood was just for trying to get the boundary line corrected with all the neighbors together, all three neighbors doing it in one fell swoop. And all the neighbors agreed except Joyce. So we just moved on and did it with just the back neighbors who were building a home. And we didn't want to hold up their process. So we did get an agreement with them as the original, where the original fence line was there, it still is. And that is the line.
Okay.
We have agreed.
Okay, yeah, and my point in looking into this is the issue of communication.
Yes.
Yes.
That's going to be, I think, important in deciding whether there was authority to take down the fence, is whether that had been properly communicated. Unless the position of Ms. Romo and Ms. Nelson is that the fence was their property and they had the right to do with it regardless. But I don't think that's your position. Am I correct?
That is correct, Honor. We showed the picture on our
trying to
photo
take a
number
fence
1.
down.
The wooden fences, the 3 8-foot panels, those are ours, not disputed. You can see attached to it is the bamboo
and the
And on the other end of it, on photo number 2, it shows the other end where the wire
has been
4-foot wire one has been reattached, so that the integrity of the fence is in place where it was. We replaced with the metal, and I know that that was not what she wanted. She wanted to keep her fence, but we did not have any indication from her until after the fact. So we kept, she has her materials, and we tried to pay for the materials through the fence company, sending a check, which it's not materials that she wants.
She wants cash, and
She wants cash. Good stuff.
look at the
Good stuff. This is a live court case in Austin County.
Joyce, that you were replacing her fence was via text, which
Austin County, Washington.
Texts are blocked, and you have the indication that you sent it, but no indication that it in fact was received, other than it doesn't have the have to try again stamp on it. So there was no conversation about this other than the one text. I want to make sure I understand this. Ms. Lieveling, is that correct?
You can just say Joyce. And can I just add, they sent a text to the
Mr. Lane
to their south that they had the property line fight with for 2 years. They waited until he responded from that text before they put their fence up on his side. They didn't wait to hear from me.
Okay. So there's been no communication, and you did not receive a text that you're saying under oath.
I've seen or talked to them since.
All right. And Ms. Romo, I think I've asked you that question before, and you agreed it was the one text and there's been no other communication.
That is correct. She has not responded, and I've not seen evidence of her responding to other.
Okay.
But I did read. We did read it to her on the day.
On the 26th, as the fence is being taken down,
As
is that
witnessed.
correct?
It was already down.
And we sent copies of it.
She's claiming that the fence was already down. So that's interesting right there.
So I let me just say this. So the amount I asked for is actually less than my out of pocket, and I'm happy with that. I just want to cover my court cost, my copying, the certified letters.
Mr. Joyce just wants money.
Detail your cost for me, please.
Oh, gosh. Okay, I think this is the first one. Okay, copies were $13.13.
Okay, let's leave copies out of it.
Pardon me?
Leave copies out of it. Keep going. Tell me what your costs are.
Do you want the fence? What is $2,900? And that's what I'm asking.
$2,000 for a
I did not
fence?
pay that. That's on hold.
The pursuit is still going on. Pursuit is still going on.
All right. With the with the parties agreeing that any determination as to ownership of the property isn't an issue for this trial, and that the sole issue was there authority to take down the fence. I'm going to find no, since there wasn't sufficient communication to Ms. Neveling, even though there was an attempt to communicate. Apparently Ms. Romo and Ms. Nelson are unaware that their texts have been blocked, but regardless, they didn't make any effort to go over and personally say, here's what we're intending to do. What are your thoughts? And without that authority, I find that the taking down of Ms. Neveling's fence, even if it's replaced by something more effective and better aesthetically, can't take down somebody else's property without their authority. So I'll find judgment for Ms. Neveling in the amount of the estimated value of the fence and the damage to the
Can't be doing
plants
it.
in the principal sum of $3,123.87.
$300.
The cost of filing and service, the judgment is $3,187.90. And that does not require Ms. Neveling to replace her fence. It's just the liability for taking down a fence without proper communication. Ms. Neveling is present in court. We'll give her a copy of the judgment, and for Ms. Nelson and Ms. Romo, you can access that judgment through your civil file at district court. All right. Thank you all.
Thank you so much.
Thank you, Your Honor.
Thank you, Judge.
You're welcome.
Straight up denied. Straight up fucking denied.
Yes, Your Honor.
I've granted judgment in your favor.
Okay.
For all $10,000 that you saw.
Oh, damn. Okay, so now let's come over here. Another small claims with a different judge.
If I can set the stage here as to what I'm concerned about. Looks like this was a lease agreement for a piece of property that's in Bothell, Washington.
Lease
Why we're
agreement.
here, I don't know, in Thurston County District Court, other than the fact, I guess, that the registered agent for Belong Inc. is registered in Tumwater.
Some landlord stuff going on.
After looking through all these documents, it looks like all the claims for damages have been paid. Is that right, Mr. Corpali?
Yes.
Clayton County
damages,
with
yes,
the first
but,
appearances
I had to file a small
live.
claims and had to go through a process. That reimbursement has not been paid to me.
And so you paid for filing fee and you paid for service of the notice, correct?
Yes, I took consultation from Scobble. The entire amount was $662.
$600.
Squabble is it helps clients like me who are unaware of the legal process for any small disputes. Like, for example, for me, it's a first time filing a small claims case. I didn't even know what to do. I consulted them if I had a case, and they said they will take care of the entire process, right from filing to serving the process for me. But they charged $662 for that filing claim, for that entire handling of the process. So they are like a third party helping agency to help people who don't know about anything about legal process.
And they charged you $262 for
$662.
$662, yes. Nothing in the sense like I had zero knowledge of how to even go ahead in this case. So they provided me guidance and also handled the entire process.
When I say essentially nothing, what I meant, Mr. Corpali, was that there are no damages. Everything's been paid now, finally, through the work of the two insurance companies. Is that correct?
That's true, but when I filed the case, I was under the subrogation letter for legally paying $3,600. So when I filed the case, I was supposed to pay $3,600 to Allstate. I was under that charge.
Ms. Silks, go ahead.
Yes, sir. Thank you so much, Your Honor. Yeah, that is correct. There was two different insurance companies that one was denying the claim and the other one was requesting to be paid. Mr. Capali was never out any funds for anything, and I let him know that I would step in to try to communicate with the two insurance companies so that it could be paid, and that's what I did. But it took a little bit of time for each insurance company to look over everything and pay the claim. So Mr. Capali was never out any money or damages whatsoever.
Wow.
So I'll ask this of both of you, and you can give me the help on the timeline. This incident happened on October 23rd or 24th, is that right? 2025?
Correct.
And there were two different companies that responded to the claim. One was ServPro and one was...
Oh, damn.
Can't remember what the other name was. Out of Kent, I think.
I could kind of clear this up if you'd like, sir.
Is that you, Ms. Silks?
Yes. What I was going to say is when the initial claim happened, the homeowner sent their own insurance company, which was ServPro, to do the water mitigation. And then after that, Mr. Capali had, filed the renter's liability insurance for the rest. So that's when the other insurance company stepped in, QBE. So QBE paid all of that part out, but Allstate had paid out the part for the ServPro. And so QBE wouldn't pay that portion of it at first because they thought it was Allstate. But what I explained to QBE, that it was part of the whole mitigation. It was part of the overall repairs for what happened. And so Allstate was trying to get their money, which is why Mr. Capali got the letter. And then I went to QBE and explained all of that, what it was. It was for the initial water mitigation that the homeowner wanted to make sure was taken care of right away. And so QBE took that all into account and took that under the overall claim for them and then paid out that portion to Allstate so that the subrogation letter was released. But Mr. Capali was never out any of those funds at all, but Allstate was looking for the funds.
Let me ask this question. When was Belong Inc. advised of this claim initially? October 23rd, October 24th?
October
when it
23rd.
happened. Yeah, when it happened.
When it happened. And did Belong Inc. indicate that that the insurance that was involved, that Mr. Corpali had purchased, or let's back up. QBE, that was insurance for Belong? Is that right?
No, we're not
Some
an
insurance
company. It's
claims.
just offered. It's an insurance company that we offer to our residents if the resident wants to purchase, wants to purchase it through QBE. That's the one that we reference, but they are welcome to get their own outside of along as well.
So, Mr. Corpali, you had both QBE insurance and Allstate?
No, I had insurance through Belong, which is QBE. Belong sold the insurance to me saying it's protected by Belong. So my insurance was managed by Belong, the property owner. I paid to Belong every month certain insurance fee, which they paid to QBE.
The Allstate was the homeowner's insurance company.
The homeowner's insurance, okay.
And the homeowner immediately, because once we were made aware of this situation, the homeowner is immediately made aware of the situation as well. And without delay, because the homeowner wanted to make sure that the home was, the integrity of the home was kept, they immediately contacted their insurance. And that's how Allstate got involved. And Allstate immediately sent out ServPro. And then later on, QBE absorbed that amount from Allstate. But at first, QBE didn't understand, so they were denying the claim because Allstate is another insurance company. So it's a different kind of, one insurance company to the other.
Ooh,
and I explained
baby.
to Mr. Capali that I would, step in and speak with both insurance companies. He was sent the letter once he provided the letter to us that Allstate was looking for their funds. I said I would step in. I did. And in that same time is when Mr. Capali had filed a lawsuit. But I did share with him that it takes some time for the insurance companies to sort this out. And it was paid. And I kept constant contact with Mr. Capali.
Let me ask you this, Ms. Silks.
Yes,
How
sir.
much money did QBE pay for the repair and restoration? That would have been to the Kent Company.
Yeah,
What
I think
was
that
that
would. I think that was for Mr. Capali. Mr. Capali would know that because it was his claim that he filed.
No. One
right?
thing to add, Your Honor. My insurance is managed by Belong. I wasn't even given the insurance papers. So here, QBE is not my insurance. It's the insurance of Belong, the property manager's insurance. So I have no knowledge of what happened between QBE and Belong or Allstate. Allstate just sent me a subrogation letter. The protection sold by Belong is I will not be involved. It's like hands off. The tenant will not be involved in insurance claim. They will be managing all the insurance claim. And they didn't even provide me the document of QBE. They call it the master insurance policy, the Belong master insurance policy.
A mass insurance
it was
policy.
QBE paid $6,452.61 for those for the insurance claim.
All right. And then, Ms. Silks, while you're looking at those numbers, ServPro wanted $3,639.70.
Damn.
Is that right?
That is correct. Actually, it was Allstate. Allstate paid them for that amount.
Right. But that's the amount that ServPro billed for their work.
Correct.
And I understand that on March 18th, QBE issued a check in the amount of $4,558.47.
Damn, $4,000.
For the ServPro damage?
Correct.
So where did the difference of $918 go?
Well, we paid Allstate. I don't know if I didn't know there was a difference of anything.
Well,
It
Allstate
clearly
wanted
is a difference.
$3,639.70, and QBE paid $4,558.47 for that same claim. The other claim we're not talking about because that was satisfied. Nobody's got a question about that.
Yeah.
So there's a difference of $918. Where'd that go?
That I'm not aware of.
Well, they didn't pay it to Allstate, right? The check went to Belong, did it not?
It came to us and then we sent it to Allstate.
The same check, or you deposited the check and paid it
It's
out?
my understanding. It's my understanding we deposited the check and then sent the check to, and then sent a check to Allstate for the subrogation letter to release it.
Okay. So that means that somewhere in the Belong file, in the Belong financials, there's $918.77 that's unaccounted for.
Yeah, where is that money?
Yeah, I don't have that information. I'm sorry. I just know what Allstate was asking for, and we sent the information from Allstate to QBE, and then they paid it to us.
They clearly didn't pay it, since it's still money pending.
Did Belong include any charge for its services in that claim to QBE?
Well, Belong offers the policy, to the residents, as Mr. Carpali said, but I don't know if we paid anything extra to QBE for it.
Well, I'm just curious.
Yeah, I just know that
Insurance companies tend not to. I mean, they're obligated to account for their funds. If they wanted $36.39.70, and QBE sends $4,558.47, there's a difference there of $918.77.
$918.
So
where's that money?
QBE sent the check to you to Belong. Belong puts it in their account, takes out $36.39.70 and sends it to Allstate. Allstate eventually issues the release of the subrogation letter. There's still $918.77 unaccounted for. Unless you tell me, Ms. Silks, that, oops, we realized that they gave us more money and we sent it back to QBE. You don't know the answer to that, okay?
I don't. No, sir. No, Your Honor. I just know that we sent what Allstate sent us. We sent it directly to QBE, and then
we
QBE
still don't have an
sent
answer,
And
Mrs. Silks.
we sent an amount that Allstate was asking for.
Well,
we're the property management company. We're not like the insurance company. We just offer that service. Yeah.
I get it. And I appreciate, I don't know if Mr. Corpali does, but I appreciate the work that you did getting in the middle, trying to explain to these two insurance companies what the heck happened in this process.
What the hell happened?
And get the insurance company to meet its responsibility and pay what it's supposed to pay, which, took quite a while to occur. And then it winds up that they paid more than what was being requested. And I'm just trying to figure out whether that is something that Belong said, well, we want the $36.39 plus $900 for the work that we did to do this. And so they issued that bigger amount, or whether that money is unaccounted for at this point. So if I say, okay, I'm going to give Mr. Corpali judgment in this case for $662 for the squabble thing, which I don't like at all. I mean, the idea, Mr. Corpali, is that most people that file in small claims court, I'd say the vast majority of people that file in small claims court don't know what they're doing and how it works. And the paperwork is designed to help you do that and understand that. And the clerk's office is there to help you do that and understand that. And it seems to me that $662 for their assistance in this matter was excessive, but be that as it may.
Yeah, so that was a big, little too much money right there.
$85 for service and $50 for filing fee. That's $1,419. That's $797. That's still less than the overage that was paid by QBE, by my calculation.
Mr. Kopali was never out any money. There was no need for him to even sue. I was letting him know that I was talking to each insurance company and sharing documents between each. I never saw a physical check myself, but I kept him updated every step of the way. So there was no need for him to even file suit.
I've seen the correspondence, and I said I appreciate the effort that you made in this. The problem is in the perception of the person who is at risk here. You didn't receive the subrogation letter, he did. And he felt that he was at risk and he needed to do something to protect himself. And what he did may have been a wise choice or may not have been a wise choice. I don't know. That's neither here nor there. So the fact that you counseled him that it was not necessary that you were going to get it fixed, that's one thing. But with the subrogation letter hanging out there, he could have felt that he needed to protect himself, so he did what he had to do.
Of course.
Exactly,
Yeah,
exactly.
So, when I called,
so Ms. Silks, what I'm saying is, if I give him judgment for $797 in this case, take that off of the $918.77, Long is still ahead by $121.77 by my calculation. So you're not out any money. Mr. Corpali's not out any money.
It did
Insurance
take me a
companies are
substantial
satisfied.
amount of time to do it. And I did share with Mr. Kopali when I called him. I was very excited that I got it all taken care of after hours of doing this. I shared with him and he was not satisfied. He had posted a very damaging review online of our services.
Oh, here we go.
And he told me that he had filed and cost him money because he used this service. And I did say, okay, what can I do to make you whole? I did ask him that, to where this review is not a reflection of our efforts anymore, because I worked diligently to try to get this taken care of for you. I put myself in his shoes. And like you said, if I got a letter like that, I would be concerned too, that I was going to be responsible for it. And so I asked him, would this, if we make you whole and make sure that everything's done and, it won't reflect the review that you posted, which is really bad, would you consider removing it? And he said, absolutely not. Even if we made him whole. And, we discussed this in mediation as well. And he said, absolutely not. He would never remove it. So I felt like, I couldn't make him happy with anything that I had tried to do along the way.
Yeah, well, I feel the same way. I'm not going to make everybody happy sitting here. So
yeah,
I
this
think
was
that's
like
what I'm
time
going
of
to do.
me.
So
I will do the same thing.
Documents that were filed in this case, I'm awarding judgment in favor of Raj Korpali against Belong Inc. Following trial today. Principal amount will be $662, $50 for the filing fee, $85 for the service fee. That's $797. And Ms. Silks, as I did my math, and I'm sure you'll be able to go back and talk to the financial people in your office who got the check and cut the check and so forth, and see what they did with the money. But by my calculation, there was $918.77 paid more than what was the total of the two claims. So this $797 that comes off of that still leaves Belong Inc. $121.77 ahead in this process. So that's my judgment. I've signed it. You each can get a copy of it from the clerk's office next week when it will be available. All right, that's all for today.
Damn. When did it plead? August 17th. Let's see. I get a 4.6 review. We are now ending on Lindsay Chan.
Ultimately, is your opinion to a degree of medical certainty regarding criminal responsibility?
My opinion is that she retained the capacities that were required for having criminal responsibility for these actions.
Thank you. Oh, and I would just like to admit Dr. Max CV as the next exhibit.
Any objection? That may be admitted.
Turn the camera on, everybody take a seat. Courtroom going live, now we're bringing you the heat.
We'll be
From the
back
judge to the jury,
later with
everybody's on
OP
screen.
Live.
We're from the Live Zoom court, you know what I mean.
See y'all later. Bye-bye.
Boots on the floor, but the courtroom's online. Judge on the screen and the cases in line. From Texas to the world, we're watching it unfold.